This is Dan Bell with PatentLawyerCLE.com. We're in the Priority Law course. After you register, you'll land here. This video will teach you the steps to go through to get your CLE. The material supporting the first part of the course here is Book 1, which we'll look at in a moment. There's an agenda here you can look at, and then there's a free gift process, which is not part of the approved CLE. It's just a gift to you in the Priority Law course. And then there's the verification recorder, which you will enter the verification codes from each hour and then obtain your certificate once you've completed that. Of course, there's course feedback you can give at the end. And then at the top left here, there's if you have a question or you need help, you can click this contact and leave a message or obtain my phone number and call me directly. There's, in this course, as it said, hours 1 through 12 are on the Priority Law course. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. And then there's some ethics materials in this course. And summary of the model rule changes, ethics of outsourcing, ethics of lawyer websites and social media, and that completes the 15 hours in this course. The course length will vary based on your state's requirements. This one is a 15-hour course for Texas on priority law. Other states also have priority law. Let's take a peek at this Book 1 here. Give you an idea. Oops, that's the second part. It's a book called Legal Process Design, which I have authored. And legal process design is the intelligent orchestration of resources to produce well-defined, high-quality deliverables according to be repeatable, trainable, and measurable and scalable processes. Of course, the book has a table of contents. There's the author introduction, which tells you all about my experience, who the intended audience is, and the book goes on to talk about business design and how you can eliminate some problems with just the business structure, and then goes on to talk about what legal process design is, gives it a definition and an example, and how it's different from the general practice of law. And then there's an overview of the structure of the book. As you can see here, the book itself has Priority Law 100, and then it has Invalidity Analysis 200, which has 3 parts to it, 2 of which are covered in the book, a spec map or spec chart 220, and then a reference chart where you map the prior references against the claim language. And then, so Priority Law is the first course, which is this course, and the next course is the spec map process design course, and then there's a reference chart process design course, and then there's infringement. The search parts are not in this book, and it's more of a technical training which would not be awarded CLE credit, so it's not included. So again, this course is the Priority Law course, and that's what's covered in this course. They go in order. The next course is spec map, then reference chart, and then the infringement chart course. These include all of these include the documents, the law, the checklists, process steps, quality metrics, and what have you. They're fully designed functional processes that have been used. And therefore it's not just a analysis of law, but it's a law and practice course. There's an explanation of what each of these processes mean. Priority law, spec map, reference chart process, and the infringement process. And then there's the business context in which these processes are used and in-house when these decisions are used then at law firms. And so it gives a nice background setup And that, of course, is the introductory first 18 pages giving you context, and then it goes into the section 1, the priority law course. The videos that I showed you a moment ago, those cover this book at a higher abstract level. They don't go word for word, obviously, and I'm just showing you the resource here. There's not time to watch all of those. It's 15 hours of video. I'm just trying to give you an overview of what's covered. Chapter 1 is the patent life cycle, and it takes you through the life of an in-house lawyer who's making decisions about when to file and what domains to file in. It gives you the constitutional basis and statutory basis of the patent life cycle, and a general overview of first to file versus first to invent. And then it gives you the statutory, the main statutes that are relevant to the patent life cycle, describing the difference of right of priority versus benefit. This is the types of applications. So this is a good background information, which we don't cover at a low level in the videos, but it depending on the level of people joining your process, whether they're new lawyers or new to the process, it'll give them a definitional understanding. That's what this background chapter 1 is about. It talks about continuity of disclosure, well-formed benefit claims to prior filed applications in the family, or right of priority. And it talks about the statutory basis for the patent life cycle. And Bay of Paris Convention, PCT. And so it gives a working knowledge of the patent life cycle. And then a discussion of maintenance fees, ownership and assignment, discussion of licensing and enforcement, whether in federal court or ITC. And each chapter finishes with questions to make sure that the reader has assimilated the information. Chapter 2 drills down into priority law and describes how to set the search dates based on the earliest effective filing date with respect to 102B, or the invention date with respect to a and just there's a visualization of pre-AIA 102A. Of course, later in the course we cover the AIA, but as you can see here, date of invention is the date you can shield back to, and the little bubble where it says prior art pointing to the left is starting on the day before day of invention. That's a visualization of pre-AIA 102A. There are visualizations of what is infringement, whether prior commercial embodiment or not, and then of course questions at the end of every chapter. Chapter 3 moves on to the question of whether to select AIA or pre-AIA, section 102. Apply the AIA version of 102, yes or no. It provides the statutory basis for making that decision, then begins to form data structures explaining filing dates, publication dates, issue dates, and going through examples so the reader can learn whether something's pre-AIA or AIA. A methodology is introduced for metadata describing what an application is, when its filing date is, and when their members, earlier filed family members, where support is for each claim in the family, whether that support is continuous, and therefore you can determine whether or not a particular application is treated under the AIA or pre-AIA. And there's metadata developed to explain all that, which is used for testing, not for CLE purposes. There's no testing for that, only the verification codes in the videos, but it's a process of teaching and development, and the book has that you can use if you're developing a team to do this work. And then of course there's examples, questions at the end. You have a example family here with a non-provisional original, NP plus, which is a continuation in part, and then a divisional, and the arrows back are pointing to earlier filed family members. You have support for certain claims, you have canceled claims, you have issued claims, and based on the filing date and whether or not there's support, you have to make that pre-AIA AIA decision, and there's many, many questions like that to beat it into their head in different configurations of family members. Then that knowledge is used to populate tables which are used in the process. Here we have data about a 892, the 301, and the 531, and you have to populate the search dates and determine whether it's pre-AA or AIA. Very practical materials, and there's just a number of them. First examples that are gone over in the book, and then after the example there's an assignment. And then there's a visualization of pre-AIA 102B. Here you have a shield filing date, which is the earliest effective filing date. There's a 1-year grace period, and then on this date here is a year before. Anything that happens more than a year before is prior art. Anything that happens on that day or after is infringement, assuming it's a commercial embodiment, practicing the claim language. Quite a bit of time is spent developing a 102E. It's a difficult topic. Of course, there's a visualization of 102E, pre-AA 102E, day of invention, of course, you can shield back to. Before the day of invention is prior art, on the day of invention or after, if it's a commercial embodiment, is infringement. Chapter 7 and 8 cover MPP pre-AA 102E and the flowcharts. Chapter 9 introduces the concept of swords and shields, which is my way of talking about the Hilmer doctrine. You can, your shield date, if you will, under 102B does not go back to a foreign filing date, only to U.S. filing dates and PCT applications designated in the U.S. And sword date implies the date a reference is effective to kill a patent. And those are terms we use to point out that a patent reference may have a different effective date as a sword or to kill another patent than it does as to shield or to block another patent trying to kill it, for example, because of, for example, the Hilmer doctrine. Since this is all developing a process that is being trained and used, it's all gets down to developing templates and expected methodologies that are used. Here we have introducing the shield and invalidity tables. A shield table tells you how far back your target can shield attacks, as far back as, for example, there's support under 102B, pre-A 102B, or as far back as invention under A&E. And then we introduce the concept of using dates in this format, which is easier for asynchronous grading purposes with the computer tools we use. And we begin more with data structures that I introduced before and add the information you need to set swords. And all of this creates a metadata that can be used to provide information quickly to the reader so they can make quick decisions about search dates, whether a reference is early enough in time to invalidate a claim. As we know, each claim in a patent can have a different search date depending on if there's earlier filed family members, and for example, its day of invention might be different than another claim. Of course, we're still talking about pre-AIA. And so what we introduce is this concept of a target family. This is the target of study, and these are potential references we use against it. And we ask if this reference, a non-provisional continuation in part, claims party to this non-provisional original, do these dates, are they early enough in time to invalidate which of these claims up here? And these same tables will be used when we switch over to the AIA law. And so here's an example assignment of that. You have the target of study. It has a family This T means that this is the target. It has an earlier file provisional in the family. And this question is asking, is this reference family, which has invalidating language for claims 1 and 2 of the target, and here invalidating language for claims 1 through 3 of the target. This is the target, or here's the target. Here's a target family. Are these dates? We have a filing date, publication date, and an issue date. That's what these 3 levels are. And so are these dates going to be early enough in time to beat this reference? And we populate tables to prove that we understand it. And that's how we develop the process to get people to think quickly about whether or not a claim has its earliest shield dates that it can shield attacks under. And that's what this is. It's a shield table. So we teach how to populate that. And then we have an invalidity table, which it's just simple yes or no that reference family. Each of these cells would have a yes or no if it's early enough in time. And that is the, if you will, the meat of priority law, making those quick decisions and not getting confused about the difference between AIA and pre-AIA, the Hilmer Doctrine and all these things, whether or not a PCT application can serve as a 102E reference, what are the requirements, all of that. That's what the priority law course is about. In Chapter 11, we introduce the concept of a sword table, which is telling us what is the effective date under 102A, we're talking pre-AIA now, of the 901 reference, what's its 102A effective date for these claims. And they have to look at the data structure and figure out what the effective dates are. And then we have a condensed cheat sheet to teach them how to set shield and sword dates. So not only do we teach them the law behind them and how to do it quickly, but also in the end, once they understand the theory, how to use cheat sheets to get quick reminders of what dates are and how to apply them. And these, if you can see each of these are questions with actual samples of swords, families, and how they're related. 903 claims to the 901, 905 to the 903, and the 909 claims to the 903 instead of to the 905. Here we have a national stage entry of the 903. Here we have a continuation. And then so you have different invalidating language present in the family when, for example, was language from claim 3 introduced, and therefore it has an earliest effective filing date in this continuation, and all of that's used to help introduce the determine the dates in the sword table. It's very technical. It's very hands-on. And then we'd introduce concepts like continuity of disclosure, incorporation by reference, and then leaves the 102E tree as the MPP discussion of 102E, which is, of course, a fairly difficult topic and fairly nuanced. And these are the leaves of the 102E tree, which I'll show you in a minute what I mean by that. Chapter 14 is about Section 103A and C, commonly owned. Chapter 15 introduces the statutory language of the AIA, Section 102, and gives visualizations here of A1. And here of A2. Chapter 16 introduces the AIA Section 102 data structures for the target family and potential references. And we've introduced inventorship to let us know who the inventor was in this in each of these applications. And we've introduced who was assigned to and on what date, which will be relevant to whether or not an application can be used if there's common inventorship. Then we have visualizations of Section 102A1 under the AIA. Here we have a set of target family, and but anything before the filing date of that is prior art, so long as it's not sourced from J. In other words, J's work can't kill J, under A1. And here we can see the B1A exception. It's saying that J's work during the 1 year before its filing date is an exception. It cannot be used against J that we saw above. And here we see that after the 1 year, or before the 1 year period, J's work can be used against inventor J under the B1A exception. Sorry to rush through these, just trying to give you an idea of what the content is. The B1B exception, if it's not J, it can be used anytime before the filing date. And the exception, of course, is if it's sourced from J. Here, this information, which becomes available before the non-J material, with respect to claim X, if that's sourced before this comes into being, from the inventors, then that information is not blocked, even though it's published before the filing date in the not J article. Right? And then more than a year before, it doesn't matter. This exception doesn't apply anymore. And under AIA 102A2, we have a family members claiming priority to earlier filed family members until you find the earliest effective filing date. And of course, the inventor here is J. Here we have invention by not J. Neither of these dates are before the date necessary here. But if they claim priority to one that's before the earliest effective filing date, then they can be used to invalidate because their earliest effective filing date is before that of the application family. Then there's the B2A exceptions. The B2A exception, here you have for example, a inventor that's not J. Here's your family you're trying to invalidate. This is not J, so it does refer to an earlier family member earlier than the earliest effective filing date. But we look here and we notice that the information is sourced from J. Sourced from J means that the information was obtained from J. That's my nomenclature. Therefore, since it's sourced from J, which is your inventor up here, it cannot be used unless it's before the 1 year grace period. So if it's an inventor's not J, even if it is sourced from J, which is your inventor up here, more than a year before, the exception no longer applies. And here's the B2B exception visualization. Here you have a sourced from not J, and therefore it should be admissible against this, again, against this J family up here, and this is the earliest effective filing date. That's what we're applying this to. And so since this is not from J, it should be able to be used, but it's not early enough, but it claims priority to an earlier filed application, which is not from J, and it's before that earliest effective filing date. However, because something was published before the date of this during the 1 year period, with respect to whatever claims disclosed there, you cannot use this reference against it, because the source for claim C of X is J, not J, except unless if this is more than a year before, then the exception no longer applies. And that's why we've introduced this authorship, inventorship, and source metadata in here, and the date it became owned by this entity. We've also introduced the concept of cancellation. That's because, as we know, under the AIA Section 102, even a canceled claim that relied on information that was filed after the AIA critical date would pull that application into the AIA territory. And so we need to know if there's any claims canceled that relied on information on or after the critical date. So then we introduce target families, which are the patent of study, and then shortlisted references. Here we have a family, and here we have a open art literature and we determine whether or not these are early enough in time for whatever search dates, shield dates we end up for this family after we've determined whether it's AIA or pre-AIA. And then we go to the gist of really what priority law is about. It's populating this shield table, first deciding whether it's treated under AIA or pre-AI, which is an application decision. Once one or more claims in that application are treated under it, the entire application is. And then we populate the dates for whether it's pre-AIA 102A, B or E, or AIA, A1 or A2. And these are our search dates for Claim 1, Claim 2, Claim 3. And then we have the sword table, which is the effective date. Each of the references in the above example could strike a target patent, and then finally an invalidity table. If that date is early enough in time, then we mark this as yes, as invalidating. And these are actually the tables that you develop in the process, which proves your evidence on your team so that it can be reviewed to make sure you have the dates right. And so that was all of the teaching that goes into this process. And then at the end, which normally we'll do at the beginning, you go through all of the process documents. And I'm going to just show you an example here. Here's priority law issue flow. It's is this patent valid? That's the first question. Then we have to ask, is this a pre-AIA application? If green, we go here. If red, we go down here. For each claim, determine the pre-AIA search dates, and you populate the table. For 102A and E, you have a day of invention or constructive reduction to practice theory, and then you determine whether or not there's an intervening reference, and then you've determined whether there's derivation, actual reduction to practice, conception before the intervening reference, and did the diligence start before the intervening reference. And all of these this is issue flow to teach how to go through these issues. And then you have it for 102B, earliest effective filing date. Are there earlier filed family members? Yes, they filed in the US or PCT. Yes, is there co-pendency? Is there previous inventor? Continued disclosure. Are there more family members? And you keep going back to the earliest family member for that claim to set your earliest effective filing dates. If there's continued disclosure lapse, then you have a problem with your earliest effective filing date, and you may in fact have a 102B invalidity. And so all of this is explained in the course also. And then you have, is this patent valid? So each of these links you click on, and it takes you to that spot. That would take you, is this patent valid? And this, of course, takes us to section 282. And, is this patent pre-AIA or AIA? And this is the statutory areas to answer that question. Continuity of disclosure and whatnot. Then you have the pre-AIA 102A checklist, which describes what each of these terms mean. They can click and read about it. Of course, they've already studied it in this, so it's a process doc now. They're going back to refresh their memory and mind about it when they're going to use it. What are these things? Day of invention, swear behind, conception, evidence of conception, unproven conception, actual reduction to practice. All of these things that were in the reading materials. And then you have the pre-AIA 102B checklist, all the major issues there that come up. And these are a subset of issues that are going to come using the Pareto analysis. They're going to, they're the 20% of the items that are going to come up 80% of the time. And that's why we're teaching them. And that's the difference with legal process design. It's a design process meant to handle a specific problem that's designed, vetted, agreed upon with the team, and then taught, tested, and then there's quality metrics and what have you. There's a 102E checklist. These are all the process documents. You have the pre-A 102E flow charts, which are from the MPP. You'll notice I've labeled each of these nodes A, B, C, D. What we do with that is in the sword tables, in addition to putting the effective date of a reference under 102E, there's a little notch next to it, and we're telling the supervisory lawyer where we ended up in the table. We ended up in leaf G and we got this date, that tells them we understand what 102E is, how to traverse these tables, and where we got. Then there's, of course, pre-AA 102E flowchart 2, WIPO publications. These are the process documents again. And then we have the main laws, for priority laws. Section 104, pre-AA, 111. I don't want to go too much detail. And then we have the data records that we talked about. Those are teach what all the metadata means. And you have the 3 different kinds of tables. They're in the process documents. Then you have the cheat sheet that I talked about, how to set sword and shield dates. And then we have the commonly owned, is it joint research agreements. And this flow chart first to determine whether the application is treated under the AIA. If yes, you go green to this side, it's AIA law. If no, you come down here. And that's the commonly owned joint research determination. And it tells you whether or not it's prior art. And each of these little questions here you click on, which will take you down into these questions here. So that if you don't remember what it means, you can read it quickly and determine. And you have the statutory support here you can click on. And then there's also NPEP support. You can click here and it'll take you. The important sections are cited in here, but if you want to go back and refresh more broadly, you can go back to these, click any of these and go back to the NPEP or the statutory basis for each of these decisions you're making. Each one of these decisions has a question, and click that, takes you down there. And so this is what a legal process design looks like. These are the process documents. There's a flow through it. There's issues you're covering. This is the AIA 35 USC 102 flow chart. Here you ask, is it apply AI version? Yes, we come over here. No, we do the pre-AIA analysis. Set the shield date for each claim in the target. Of course, we look for earliest effective filing date, continuous support, and whatnot. And then after we've set those dates, we come down here for search strategy. We look for 102A1 references, which are accessible for the earliest effective filing date of this claim. And then once we've found a reference that teaches whether it's under 102, anticipation or obviousness, then we move down here and ask, do any of the exceptions apply? And like in the other flow chart I showed you, when you're wondering whether or not a section applies, you just clicked on it. Hey, boom, click this, it'll take you down and explain what the exceptions are. There's and these inventors sourced prior art more or less than a year before the earliest effective filing date. That would not qualify. It has to be more than a year. Intervening after inventor source. So the intervening reference is after the inventor sourced that information in the public domain for that claim. And then so these exceptions, this is saying if it's not prior art, it's a Y in the leaf in the sword table. If it is prior art but an exception applies, that's an M. And so that's how these work. And then of course on this side it found 102A2 AIA art, which is patent documents effectively filed before the earliest effective filing date of this claim. Once you find one of those, you look at the 3 exceptions. Disclosure matters sourced from inventors, patent document discloses after inventor source, or commonly owned. And of course, commonly owned questions. You go back to the flow chart above we saw. And so each of these, when you give the supervisory lawyer a code that there's an exception, you give them the R code, and that tells them that you got through the flow chart through all the way down to here, and then you exited to not prior art. If you pop out the bottom, meaning none of the exceptions apply, then it's prior art. And all of this information, of course, and how to answer these questions is included in these. Click on any of these Q4, QA, that'll take you down below into the document. And this is how you answer the questions. And this, of course, is the statutory or MP basis for the determination that you're making once you're looking at a 102E reference. And so it's a formalized process. So rather than just going through it as an art and remembering, hopefully remembering, you're going through, looking at flowing through this process. And then each of these courses has supplemental reading, which is case law, which will help them understand the nuances that are involved in some of these decisions they're making. So they have the theoretical underpinnings. I believe there's about 60 pages of supplemental reading in this process, which is mainly just case law. And as I say, the last 3 hours of this course are on ethics. There is depends on your state, but this is for Texas, and there's the ABA model rule changes, where they're located, what they mean, and there's ethics of outsourcing, and which is something I know something about. I've been involved in that, and might be an interesting read for you, or video listen, and of course there's written materials for each of these subjects. And then the final hour just completes a little bit on ethics of outsourcing and then moves over to ethics of lawyer websites and social media. And again, there's written material for that. You can click on and follow along or read or keep, whatever. And then, of course, that in this case, it's 15 hours of CLE, and you go up to the recorder, and each of those hours had a code in it. You click on this, fill in the code, and then get your certificate. There's directions of how to use the verification recorder here at the top in courses, so you can watch that if you want to understand how to put in the codes. So that is what's in the priority law course. We invite you to join and read and watch and obtain your CLE for priority law and ethics.